Part 2 of Concurrent Conflicts of Interest. The rationale for conflicts of interest rules. This brings us to the rationale behind the rules for conflicts. There are two primary concerns: protecting client confidentiality and honoring loyalty to the client. If a firm had the right to represent both clients with conflicting interests, there is a risk that confidential information from one case would be available to opposing counsel in the other case. Since attorneys within a firm are generally entitled to and motivated to share confidential client information with one another, representing conflicting interests would compromise the client's right to confidentiality. For example, counsel for the employee might discover information about Corporation A's financial situation that she has no right to know, and this might give counsel an advantage in negotiation strategies in the employment case. A second rationale for conflicts of interest is not related to confidentiality or any likely harm to the client. Instead, the principle of client loyalty holds that a client should be able to count on her own attorney for not taking on a case for, quote, the other side. See Comment 2 to Rule 1.10. The principle of loyalty is important when attorneys are concurrently associated in a firm. It may give way when an attorney moves from one firm to another. Where the conflict of interest is a personal conflict of one attorney within the firm, this conflict is generally not imputed to the entire firm. For example, if partner Jones has a strong moral or political belief against representing a particular client or interest, Jones's personal beliefs would not prevent partner Smith from taking the case. Likewise, if Jones had outside investments that could be harmed by the case, this would not prevent Smith from taking the case. Note, however, that sometimes personal conflicts of interest might create a conflict for another lawyer in the firm. If Jones were the founding and managing partner, Smith might not be able to handle a case that put Jones's outside financial interests at risk because Smith is dependent on and highly respectful of Jones. Waiving conflicts of interest. Now that we've dealt with both the individual attorney and the firm of attorneys, let's return to how might one have clients waive conflicts of interest. Comment 18 and 19 to Rule 1.7 point out that both clients must be fully informed by the implications of common representation, including possible effects on loyalty, confidentiality, privilege, and all advantages and risks. Sometimes confidentiality may make it impossible to provide both clients with full information so that they can give informed consent to the conflict. If the firm must make disclosures about one client's case to the other client, and the first client refuses to consent to that disclosure, then the conflict cannot be waived. Common representation. One very typical sort of representation where conflicts are waived by the clients is called common representation. See comments 29 through 33 to Rule 1.7. Let us imagine three friends forming a business together, or a husband and wife retaining one attorney to prepare wills for them. This is a typical sort of common representation. Ordinarily, at the outset, the attorney will wish to have the client's consent to sharing all confidential information between or among the common clients. In common representation, the prevailing rule is that there is no privilege as between commonly represented clients. If a conflict develops between or among the common clients, then the attorney will ordinarily need to withdraw from representing any of them. Issue conflicts. There is another less typical sort of concurrent conflict of interest, and this is an issue conflict. The iconic case of Westinghouse Electric versus Kerr-McGee provides an instructive example. In that case, the large firm of Kirkland & Ellis had offices in different cities. The Washington, D.C. office was representing the American Petroleum Institute, of which Kerr-McGee was a member, in lobbying matters and was arguing that the energy industry was highly competitive. At the same time, the Chicago office of Kirkland & Ellis had just instituted an antitrust case for Westinghouse against Kerr-McGee, arguing that there was a price-fixing conspiracy in the uranium industry. Both assertions could not be true. Counsel for the defendant in the antitrust case moved that Kirkland & Ellis be disqualified from the case due to this conflict of interest, and the Seventh Circuit agreed. The point was that the firm could not be simultaneously arguing opposite propositions in such a public way. While most attorneys and firms will not find themselves in Kirkland and Ellis's situation, it is important to avoid taking diametrically opposite positions in any forum where the firm will be seen to be speaking out of both sides of its mouth. Who is the client for conflict analysis? Another point should be taken away from the Westinghouse versus Kerr-McGee case, and that is that the identity of clients for purposes of analyzing conflicts of interest is not rigidly governed by corporate formalism. In this case, the firm represented a trade group of which Kerr-McGee was a member. This was seen by the court as tantamount to representing Kerr-McGee, since the trade group was carrying out the interest of Kerr-McGee and others within the industry. The court found that while there was no express attorney-client relationship, there existed a fiduciary obligation and implied professional relation. The court also relied upon the fact that Kerr-McGee had transmitted confidential information to counsel for the American petroleum industry. This is a general point that will come up in many other settings where conflicts of interest are raised. The court will look beyond the formality of which corporate entity is the client and consider whether others may be quasi-clients because of their unity of interest. In the Utah case of Margules by Margules versus Upchurch, the firm brought suit against various individual doctors while also representing the limited partnership in which these doctors were limited partners. The Utah Supreme Court implied the existence of an attorney-client fiduciary relationship with the individual doctor partners and held that this was an impermissible conflict of interest. The firm was disqualified from the lawsuit against the doctors. Motions to disqualify. This brings us to our final point for today. Conflicts of interest rarely come to the attention of the bar through disciplinary matters. Instead, the law surrounding conflicts is developed when attorneys in litigation bring motions to disqualify opposing counsel because of alleged conflicts of interest. Now, these motions are not always entirely pure actions to enhance fairness. Filing a motion to disqualify can be a strategy to eliminate a lawsuit by preventing the opposing party's lawyer from continuing in the representation. When a court finds an impermissible conflict, the court disqualifies counsel. At that point, counsel doesn't get any attorney's fees, and the client, left high and dry, may have a colorable claim for malpractice against his former counsel. Motions to disqualify can also occur in criminal matters, where the damage is further delay and difficulty as new counsel is found, whether appointed defense counsel or a different prosecutor within the agency or a special prosecutor outside. For these reasons, it is very important to understand conflicts of interest and to analyze this issue when accepting a new case. This brings us to the end of the introduction to concurrent conflicts of interest. Please listen to Part 2 of concurrent conflicts of interest before our next class.